Hello again, this is Jim Maroney. In part 3 of this competing interests, let's start off this section with trustee versus those who received preference payments. When we do your bankruptcy petition, we're going to be asked a lot of questions having to do with preference payments. They're not going to tell you preference payments when they ask you the question, but they're going to ask you underlying facts that will disclose whether or not there were preference payments. So what are they? Well, from the day that you file, going back in time 90 days, let's assume that you paid an unsecured creditor more than $600 during that 90-day period. So if you made $250 payments for each of 3 months during the 90 days, that's a preference payment. Let's give an example so you can understand. Let's say that you meet with me or some other attorney, and you learn what assets are protected in bankruptcy, and you also learn that you have to list all your creditors. So let's assume that you're halfway through getting your teeth repaired, and you sure want a dentist to feel good about you if he's putting needles in your mouth. So you might reason, well, I'm going to go ahead and pay that dentist off before I file bankruptcy. And let's assume that you owe the dentist $1,500. So during the 90 days before bankruptcy, in one or more payments that total, you've paid the dentist $1,500. Well, your dentist is an unsecured creditor. So what's going to happen, the trustee will learn that you have paid that dentist $1,500 during that 90-day period. So the trustee is going to contact the dentist, and he's going to say, hey, you collected $1,500 during that 90-day period. You're going to keep $600 of it, and the rest of it you're going to mail into me. And I'm going to distribute that money, which would be in our case $900. I'm going to distribute that $900 to all of your unsecured creditors pro rata. So you can see that that's a real inducement not to be making preference payments. Now let's draw a distinction. That preference rule for 90 days, that only applies to unsecured creditors. So if you're making your house payment or your car payment, some payment to a secured creditor, that doesn't come within the rules for preference payments, so you don't need to worry about that. It's interesting, if you'll note, if you paid that money during the 90 days before bankruptcy, the trustee's going to grab it and pay it among all of your unsecured creditors. But if you'll wait until your bankruptcy petition is filed, if you're in Chapter 7, you can make any payment you want to that dentist or any other creditor. Sometimes people will reason, well, I've got a very low balance on my credit card, so I'm going to go ahead and pay them off so that I don't have to list them in my bankruptcy. Well, that's not good reasoning, and let me tell you why. Most credit card companies are going to cancel your card. They watch to see who files bankruptcy. When they learn that you have filed bankruptcy, they're going to cancel your card, whether you paid in full or not, whether you even have a zero balance. The reality of it is, if you'll wait 60 or more days after you file bankruptcy, you're unfortunately going to get all kinds of credit card offers. Now, I have a session on this website dealing with what I call the betrayal of the American people. And if I was ever going to use profanity, I would use it when I describe the credit card industry. They have victimized and tyrannized the American people. So I hope you never use another credit card in your life. You can use debit cards, you can use all kinds of things. In our private lives, if you learn that someone is dishonest, what do? You quit dealing with them. Well, the credit card industry is a bunch of crooks. The banks and the credit card industries, they're not people you need to deal with. So I hope you never use credit cards, but whatever the situation, at least on this immediate subject, don't pay those credit card people off. It's just money wasted. Now, the next section, let's hit that because this is very important. First of all, who is an insider? Well, an insider is, the bankruptcy code defines insider in very broad terms, and it leaves the definition in particular circumstances up to the bankruptcy judge. So he can expand or contract that definition of insider any way he wants to. Basically, an insider is somebody that you paid money to, that you care more about than you would your other creditors. It might be a relative. It might be a partner in your business. It might be your boyfriend or your girlfriend. Someone that you're going to pay or transfer property to. And your reasoning might be, well, I'm going to file bankruptcy, so I'll just go ahead and give that to an insider. Well, there are rules against that, and the trustee can go back from filing day. The trustee can go back for 2 years and get all the money that you paid to those insiders. If it's fraudulent, he can go back 10 years under the Missouri law of fraudulent conveyances. So do not make any insider payments. When you meet with me or any other competent attorney, we're going to ask you about insider payments because we want to protect you. I don't want you getting in trouble over that, and I don't want those people that you care about, your boyfriend or your girlfriend or someone else, to have to give money back. We can plan around that. We can do different things. We may have to delay your filing date of your bankruptcy so that 2-year period runs. But you and I need to explore that when we meet. Insider, by the way, doesn't mean that the insider, that's a negative term. It just means that that's someone that you care about. Now, people that don't know these rules, they get themselves into trouble at times. And let me give you an example of a recent case that was here in the Western District of Missouri. A young lady, she was recently married. She went to her dad and she said, "Dad, my husband and I would like to buy a home. Now, we don't have the money for a down payment right now, but here's what we've got going. I've got a pension plan that will make money available to me early next year, and my new husband is going to get raises. So here's what we're going to propose. If you will lend us $35,000, we want to buy the house right now. And then early next year, we'll take the pension plan money and the wage increase money, and we'll repay you the $35,000. Well, that's an upfront deal. There's all kinds of parents that help their children in that kind of a circumstance. Well, unfortunately, the young lady and her husband filed bankruptcy. So when the trustee found out about the $35,000 transfer, he said, well, now wait a minute. When you and your husband repaid the $35,000 to your father, there wasn't an immediate transaction there. You were paying your father for a prior debt. A prior debt, another word for that in the bankruptcy, is called antecedent debt. You paid him for a debt that you already had with him. Therefore, the trustee contacted the father and said, look, I want that $35,000. That was an insider payment made within 2 years of bankruptcy, and therefore that $35,000 is going to be shared equally or pro rata among all the unsecured creditors. Now, I'm sure the father, when he loaned that money, certainly didn't expect that kind of an outcome, and I'm sure his daughter didn't either. So when we meet, you and I need to cover all the insider payments. If you've transferred anything, a car or anything else to an insider, you and I need to discuss that so that we know that we're protected. Now, let's assume that you had a transaction with your brother-in-law and you titled a car over to him, and in return he paid you the full value of that car. Well, there's nothing wrong with that because you paid for the car. You did not pay for an antecedent debt. You did not pay for a prior debt. You see the distinction? So those are things that you and I need to watch for as we're going through and getting ready to do your bankruptcy.